Well, it looks like Nicko Romeo Lacoste is about to get a royal legal slapdown. That is a strategic lawsuit against public participation slapdown. It's a law joke. You'll get it by the end of the vlog. Viva Frei, Montreal litigator turned YouTuber, and it looks like I'm going to be doing car vlogs for the foreseeable future because even by the time this lockdown is lifted, the kids are going to be out of school for the summer. But I've got to say, I think I like my car office. Lots of good lighting, fresh air, I can hear the birds chirping. Right on cue. I swear to you there was no editing involved in that. In some non-My Sharona Cyrus related news, because despite how we may feel sometimes, there still is a world out there above and beyond the My Sharona Cyrus, there have been some developments in the Nicko Romeo Lacoste lawsuit against Keemstar. For those of you who may not know, a California tattoo artist who goes by the name of Nicko Romeo Lacoste is suing Daniel Keemstar Keem for $3.5 million for various reasons. Nicko's lawsuit against Keemstar alleges two claims. One is for interference with prospective economic advantage, and the other for interference with contractual relations. Now, I've already done 2 vlogs on the subject because the lawsuit itself is actually quite interesting, and the lawsuit as drafted can teach us a very important lesson about watching what you allege in proceedings, specifically as relates to making highly prejudicial judicial admissions in the context of those legal proceedings. I'm going to link those videos right here. If you haven't already seen them, give them a watch because this vlog will make a lot more sense. But for those of you who don't have 20 minutes right now, the 30,000-foot overview. Daniel Keemstar Keem has a YouTube channel called Drama Alert. In a way, it's kind of like the National Enquirer of YouTube, although I do think Keemstar's track record, although flawed, is nonetheless more accurate than the National Enquirer's. Keemstar on Drama Alert did a few videos covering a story about a very famous California tattoo artist who apparently engaged in inappropriate texting with underage people. I have to weigh my words in the manner in which I describe this so I don't run into the same problems I ran into with my Elon Musk video where YouTube demonetized my video for actually just reading from the legal proceedings in that case of Unsworth versus Elon Musk. Keemstar did a number of videos on this very famous California tattoo artist engaging in inappropriate texting with people under the age of 18, and in a few of those videos, he referred to Nicko Romeo Lacoste as a potato. Not a potato file, just as a potato. He referred to Nicko as a potato. Nicko himself admitted in engaging in the activity that Keemstar was reporting on. Keemstar did an interview with at least one of the alleged victims or recipients of the texts from Nicko, and apparently Nicko also sent videos to this individual, and Nicko ended up suing Keemstar for damages. Nicko sued Keemstar on the basis that by referring to him as a potato, he interfered with prospective economic advantages and interfered with some of his contractual relations. In that lawsuit, Nicko alleged that he had lost employees as a result of Keemstar's coverage, that he had lost business as a result of Keemstar coverage, and he seeks to hold Keemstar responsible as a result of that coverage. I went through and broke down Nicko's lawsuit, and I pointed out that it contained some very serious problems, most notably the judicial admission that Nicko in fact engaged in the conduct that Keemstar reported on. And on May 1st, 2020, Daniel Keemstar Keem filed a special motion to strike on the basis of certain anti-SLAPP legislation in the state of California. If you have never heard of the term SLAPP suit, SLAPP, or anti-SLAPP, SLAPP stands for Strategic Lawsuit Against Public Participation. And they are exactly what they sound like. They are lawsuits taken not for the purposes of winning, but for the purposes of silencing. Everybody knows that litigation is a game of attrition, and it tends to favor those with deep pockets. And at some point, legislators were faced with the problem that people were in fact taking lawsuits not because they thought they had any reasonable chance of winning, but just because they thought they could suppress the opposing views by filing those lawsuits. And so countries, provinces, states enacted legislation to combat the SLAPP lawsuit. That's sort of a redundancy to refer to it as the SLAPP lawsuit, but they enacted anti-SLAPP legislation. And California is no different. A very summary introduction and overview of California's anti-SLAPP laws. The California anti-SLAPP law was enacted by the state legislature almost 20 years ago to protect the petition and free speech rights of all Californians. Amendments have been made since that time to improve the law and provide stronger protection from meritless lawsuits to anyone who is slapped in California. And this brings us to the relevant provision for the purposes of this vlog, the California Code of Procedure Section 425.16. California's anti-SLAPP statute provides for a special motion to strike a complaint where the complaint arises from activity exercising the rights of petition and free speech. The statute was first enacted in 1992. Yes, and in addition to birds chirping, I also get to hear dogs barking in my home office. It's not my dog. My dogs don't bark. They are perfectly well behaved, just like my kids.
Back to the video.
And what does Section 425.16 say? Let's give it a read. The legislature finds and declares that there has been a disturbing increase in lawsuits brought primarily to chill the valid exercise of the constitutional rights of freedom of speech and petition for the redress of grievances. The legislature finds and declares that it is in the public interest to encourage continued participation in matters of public significance, and that this participation should not be chilled through abuse of the judicial process.
To this end, this section shall be construed broadly.
A cause of action against a person arising from any act of that person in furtherance of the person's rights of petition or free speech under the United States Constitution or the California Constitution in connection with a public issue shall be subject to a special motion to strike, unless the court determines that the plaintiff has established that there is a probability that the plaintiff will prevail on the claim. In making its determination, the court shall consider the pleadings and supporting and opposing affidavits stating the facts upon which the liability or defense is based. If the court determines that the plaintiff has established a probability that he or she will prevail on the claim, neither that determination nor the fact of that determination shall be admissible in evidence at any later stage of the case, or in any subsequent action, and no burden of proof or degree of proof otherwise applicable shall be affected by that determination in any later stage of the case or in any subsequent proceeding. So before getting into Keemstar's special motion to strike, and sorry about this little piece of light that's going to be very distracting for you, the last portion of that provision is very interesting. In order to succeed on the special motion to strike, the petitioning party basically has to show that the plaintiff has no probability of prevailing on his or her claim. What this provision says at the end is that a determination to this effect on a special motion to strike has no lasting impact on the merits of the claim. More simply put, if a special motion to strike gets dismissed, the plaintiff can't use that as some sort of evidence later on in the file to show any sort of legitimacy to the claim. With that said, let's just get right into Keemstar's motion, and those are words I never thought I would ever be uttering in my entire life. Defendant's notice of motion and motion to strike complaint pursuant to CCP 425.16 Memorandum of Points and Authorities in support thereof. To the court, all parties, and their attorneys of record. Please take notice that on June 1, 2020 at 9 a.m. or as soon thereafter as this matter may be heard before the Honorable R. Gary Klausner. Yada yada yada. Defendant Daniel Keemstar Keem. DBA Drama Alert. Defendant will and hereby does move the court for an order striking plaintiff Nicko Romeo Lacoste, plaintiff, complaint, and awarding defendant his attorney's fees and costs. This special motion to strike is made on the grounds that 1. Plaintiff's complaint and each cause of action alleged therein against defendant arises from acts of defendant in furtherance of his right of free speech under the United States Constitution and the California Constitution in connection with a public issue, as that language is defined in Code of Civil Procedure 425.16 E3 and 4. 2. Plaintiff cannot establish that there is a probability that he will prevail on the two claims in his complaint. 1. Interference with prospective economic advantage, count 1, and 2. Interference with contractual relations, count 2. So that is where we are going. The next 5 pages are a rather meticulous table of contents setting out the sections and the authorities relied upon, but let's get into the motion itself. California enacted its Anti-Slapp statute,
Baby glove, slap.
Code of Civil Procedure section 425.16 to deter precisely the type of lawsuit being prosecuted here. One seeking to silence a YouTube news reporter with non-specific business interference claims seeking $3.5 million in general and special damages as well as punitive damages and injunctive relief. We get into a very detailed breakdown of the facts. We don't need to go over it again. I'm going to link this motion in the pinned comment below so you can give it a read at your convenience if you so choose. Suffice only to go over the headers of the facts. Keem operates a popular YouTube news channel and Romeo is a celebrity tattooist and social media influencer. 3 girls accuse Romeo of engaging in improper conduct with minors on Twitter. On March 16, 2019, Drama Alert reports on the Twitter accusations against Romeo. In his March 17, 2019 Drama Alert interview, Romeo admits that at least some of the allegations are true. In his February 10, 2020 Drama Alert video, Keem reports on a new claim against Romeo made by a 16-year-old girl. Romeo threatens Keem with a defamation action on or about February 13, 2020. Romeo's tortious interference complaint admits that he engaged in the activities with minors. These are comments and observations that I made in my 2 previous vlogs on the subject. In an interview on Keemstar's channel, Nicko admits that he did what he is being accused of having done.
Are you guilty of these things?
I want to say that some are real and some are fabricated. I do.
Well, were you sexting with 14 and 15-year-old girls?
Well, here's the thing, so...
More shocking than that, he, through counsel, makes the same admissions in his own legal proceedings. On February 10, 2020, defendant publicized a video recording of a conversation plaintiff was engaging in conversations of a sexual nature and an interview with the recording's creator. This recording was made by the individual with which plaintiff was engaging in the sexually charged conversation. This individual was a minor, hereafter known as Person A. Person A falsely told plaintiff that she was of a majority status. Plaintiff had no prior knowledge of the recording, nor had he given consent for its creation. And that in law is what we refer to as a judicial admission. It cannot be taken back or simply walked back on. Nicko made a judicial admission of the material fact upon which Keemstar's reporting was based. And as far as it goes for claims for tortious interference, it requires an underlying tort. Typically, in the absence of an underlying tort, you don't have tortious business interference because there is no tort. Uttering truthful statements, even if they do have a negative impact on the business of the subject of those statements, does not qualify as tortious business interference. I don't think Nicko's lawsuit stands any reasonable chance of success because because he's admitted the material facts that are at issue. The underlying tort cannot be defamation anymore because truth is an absolute defense to defamation. So in the absence of an underlying tort, Nicko simply doesn't have recourse against Keemstar for tortious interference. Code of Civil Procedure 425.16 provides a means of quickly disposing of actions intended to, quote, chill the valid exercise of the constitutional rights by authorizing a, quote, special motion to strike any SLAPP suits or cause of action arising from the exercise of one's rights of petition or free speech under the United States Constitution. And here is the legal part where we get into the two-step process of adjudicating on an anti-SLAPP motion. Adjudicating an anti-SLAPP motion is a two-step process. First, the court decides whether the, quote, defendant has made a threshold showing that the challenged cause of action is one arising from protected activity. The burden then shifts to the plaintiff to demonstrate a, quote, probability of prevailing on the merits. So the petitioning party must first prove that the lawsuit relates to a protected activity, in this case that being the freedom of speech. If the petitioning party, and that means the party that has filed the special motion to strike, can meet that threshold, then the burden of proof is shifted to the plaintiff, who has to show that he or she has a probability of prevailing on the merits. Keemstar then proceeds to allege as follows. The anti-SLAPP statute protects statements made in a public forum in connection with an issue of public interest. As set forth below, the statements were made, 1, in a public forum, and 2, in connection with a matter of public interest. The public forum aspect is pretty obvious. Websites that are available to the general public are recognized as public forums for the application of anti-SLAPP laws.
Coming through, challenge dual high Lenny, how dare you, demand satisfaction.
And the aspect of public importance seems pretty obvious to me as well. Romeo Lacoste is a pretty big deal in the tattoo world. Nicko is a huge influencer. As of shooting this vlog, he has something like 1.8 million followers on Instagram. That might be down from 2 million at its peak, but he's got nearly 2 million followers on Instagram. He has tattooed celebrities like Ariana Grande, Justin Bieber, and Odell Beckham. It seems relatively obvious to me that the issues at the heart of this lawsuit are of sufficient public importance given the status of Romeo Lacoste. Section 425E3's requirements that the challenged activity be in connection with an issue of public interest is to be construed broadly so as to encourage participation by all segments of our society in vigorous public debate related to issues of public interest. Plaintiff cannot establish a probability of success on the merits. Both of Romeo's tortious interference claims are barred by the First Amendment. Claims which are similar to defamation, such as tortious interference with contractual or prospective relationships, are subject to the same First Amendment requirements that govern actions for defamation. We then get into an analysis of the criteria that must be met in order to succeed on a claim for tortious interference with prospective economic advantage. The elements of tortious interference with prospective economic advantage in California are 1. An economic relationship between the plaintiff and some third party with the probability of future economic benefit to the plaintiff, the defendant's knowledge of the relationship, intentional wrongful acts on the part of the defendant designed to disrupt the relationship, actual disruption of the relationship, and economic harm to the plaintiff proximately caused by the acts of the defendant. Setting aside that I think Nicko is going to fail on one of the essential conditions, that being the actual tortious act, he has to be able to prove the loss. I'm not even of the opinion that Nicko even alleged in his original lawsuit the actual damages he actually suffered. It's not enough to say, I think I was harmed by his statements, even though I actually admitted the truthfulness of those statements. You have to show the damages sustained. You not only have to show the actual damages sustained, you have to show the proximate connection between those damages and the wrongful statements. And in my humble opinion, I think Nicko stands absolutely no chance of doing that, if only by his own admissions in his own lawsuit. Here, plaintiff has not identified any specific opportunities that he lost and of which defendant had knowledge and intent to interfere. Plaintiff has merely asserted in conclusory fashion that defendant interfered with, quote, his previously consistent stream of clients and revenue, and has failed to plead facts in support of this conclusion, which is insufficient. And then, because as we say in Quebec, trop fort casse pas, which is French for too strong doesn't break, Keemstar addresses the allegations for interference with contractual relations. In order to state a claim for intentional interference with contractual relations, a plaintiff must specifically identify the contracts, the terms of the contracts, and how the defendant would have known about them. Bottom line here are the deficiencies in drafting of Nicko's original lawsuit. Above and beyond the judicial admission, which I think puts an end to Nicko's lawsuit on its face, there is simply a dearth of allegations to support these claims. For the foregoing reasons, this court should grant defendant's special motion striking the complaint and award defendant his attorney's fees and costs. Keem respectfully requests that the amount of the fee awarded be reserved for later briefing following the hearing on this motion. And I'm calling it now. My prediction is in. Keemstar is going to succeed on this motion. Alright, and that is today's vlog, and it couldn't have come any earlier. I see that my camera is actually overheating and is going to shut down in 20 seconds. If you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification. Free advertising for FedEx. I did not plan that. Share my channel with someone who you think might appreciate it. Drop a comment in the comment section below because it feeds the algorithm. If you want to support the channel, all of these support links are in the pinned comment. We've got merch, I've got PayPal, Patreon, Subscribestar, I don't know, all the stuff. YouTube members, people on Subscribestar, Patreon get sneak peeks, which is why you might sometimes notice that there are comments that are a few hours old on a video that I just published. It's a minimal perk, but it's the best I can do on my bandwidth. I am a one-person show, even though I have a massive amount of support from my wife and kids. And with that said, above all else, take care of yourselves, stay safe, stay healthy, check in on your neighbors, and now you know your vlog. Peace out. Booyah!